Hey guys, got a legal tip for you today. Non-allowable VA fees. My thanks to Linwood for helping me figure this one out. She called the other day with a really cool question. Can a veteran buyer using a VA loan, can they pay part of the real estate agent commission or fees? And that was a question I've never heard of and really never thought of, but apparently Lynn was able to find that answer out for us. And what the situation is if you have a buyer under a buyer representation agreement, typically it says that the listing agent will pay you the commission. But if you're unable to get paid by the listing agent, that the buyer will agree to pay or to pay the difference in whatever the percentage is that you've set up. So that can come into play when you have a seller that's only paying a small portion, a small commission, and you want to have the difference made up by your buyer. And so I know the answer. Linwood found it out for us. So let's go over real quickly what our truly non-allowable fees are under VA loan. But then I got something really, really funny I got to show you at the end of this. So I'm going to pull that up in a minute. But let's go through this first. Real estate broker agents' commissions cannot be paid by a veteran under VA loan. So that's the answer to the question. They cannot do that. Attorney fees charged by a lender cannot be paid by the veteran, but attorney fees can for the attorney that they're using for the closing. What we're talking about there is where we have a lender. I know of one of them that has a law firm in Texas. They pay like $85 for reviewing of the lender documents. So they would not be able to pay that fee. Fees for appraisals are okay, but not for reconsideration of value. Any second appraisal could not be paid by the veteran. Fees for appraisals requested by anyone other than the veteran or the seller, and flood zone determination fees cannot be paid as VAs. Those are truly non-allowable fees. Now, that doesn't mean that if the buyer can't pay them, that they automatically get moved over to the seller side. It does mean that the loan officer can pay them, the lender can pay them, or the real estate agent can pay those fees. So oftentimes you will not see a flood zone determination fee charged in the closing because they're eating it as part of their origination fee or their processing fees. So that is the answer to the non-allowable fees question. But now I got to pull this up because this is rather hilarious. So as y'all know, a lot of the younger Z generation people don't have checks. And I've had to fill out lots of checks for people at a closing, and I assume that you probably had to do that as well. Here's one of my favorite ones that I just received. I don't know if anybody can notice what's wrong with this check. There's two big things wrong with this check. First of all, we have absolutely no information about whose account it is up here, so that's already a problem for me. But look at the signature line. There's no signature. They signed it earnest money. I love that. The person who gives me the check just signs it earnest money. So I thought that was kind of funny, kind of cute. So yeah, we're the last generation of check writers probably. So I don't think these new kids, the Z generation, is ever going to write checks, but that was something else. Anyway, check our blaircato.com website. You can find new classes that are now being offered. We've scheduled the dates with CCRA for our next MCE class, as well as the real estate ethics class for the realtors, as well as our brokers in charge class. So all that should be up on our website. If it's not up there by today, it should be up there tomorrow. And so check that out. We're also linked there for our podcast, all of our old legal tips and things of that nature. So thank you a whole lot. Hope you have a great weekend.